What you've said about that convention, the New York Convention, indicates that arbitration happens not just on a national level, but also on an international level. What sort of disputes are most likely to go to arbitration, and why?
Well, the most likely to be commercial disputes. And the reason for that is that the parties need to have agreed to arbitrate, and once a dispute has arisen, they're less likely to reach an agreement. So arbitration agreements are normally found in commercial contracts. Right. So that's the foundation of the agreement to arbitrate, and as a consequence, you will find them mostly in commercial contracts, not in individual contracts. There's some consumer contracts. Sometimes the vendor of consumer goods will put in an arbitration clause.
What about the Court of Arbitration for Sport then? That seems like an unusual field to be using arbitration in.
Oh, yeah, well, that's a very, very good example of almost trade bodies setting a standard procedure and encouraging the use of arbitration rather than courts. The Court of Arbitration for Sport deals with all sorts of different issues, doping disputes, the Olympics, all the disqualification of the Russians from the Winter Olympics. Constantly, I read reports of the cases relating to football managers and football players who've run into problems with their clubs, transfer fees and all sorts of stuff, disputes with their agents, masses of stuff. But they choose arbitration because it takes it out of the national courts and it puts it before a body of arbitrators who are experienced in these particular types of issues, and it's very international. So there'll be one minute they'll be trying a case involving Russians, the next one it'll be some South American football team, and then it'll be, a European cyclist or something of that nature.
Very good, interesting.